I will talk about the GDPR today. First of all, I'd like to give you a quick introduction about the GDPR in general. GDPR stands for the General Data Protection Regulation, which was put in effect since 25th of May 2018. The overall idea was to unify the data protection regulations within the European Union, since every single country had their own and very different regulations in place before. For Germany, as in most cases, Germany already had the strictest regulation in place before that date. So that meant Germany was facing the least changes according to data privacy. But still, there was quite some interest from the public and also from our customers into GDPR and what was changing related to that. The most interesting and most interesting part of it is that the fines and penalties are up to 20 million euro or 4% of the group-wide revenue. Before that, these fines were limited to a maximum of 200,000 euros per data privacy fault. So that was a complete different story before the GDPR. So let's talk about what regions, to what countries the GDPR applies. So first of it all, it applies to all the 28 countries that are members of the European Union. Plus, it also applies to Iceland, Liechtenstein, and Norway, which are part or which build the European Economic Area. Even more interesting is that the GDPR also applies for every single organization around their globe, which is processing data, personal data of an European Union citizens, or which is offering goods or services within the European Economic Area or the European Union in general. So what is personal data? So for sure, you think about name, surname, you think about personal email addresses, you think about your social security number or ID card number. You might also think about medical data or religious information, things like that. But personal data, according to the GDPR, also includes information like a cookie, which is saved in your browser. It also applies to location data that is, for example, shared while using your cell phone. So that personal data is much more than what we think about as being personal data. Let's talk about the key aspects of the GDPR, of that regulation. It can be easily summed up in a fair and lawful processing. What is meant by that? So in a general sense, lawful processing excludes any form of processing that would violate a law or regulation, may it be civil or criminal. It also includes the breach of a duty of confidence, or let's say the infringement of copyrights, for example, or the breach of a contractual agreement. So that is all understood as fair and lawful processing. As with every regulation, this is now pure, let's say, law language. So what we need to really understand that is, let's say, some showcases what really is meant by that fair and lawful processing. So what I was sharing with you is just some examples what is understood as fair and lawful processing, but there might be even more to that. What I've shared with you, that is according to the latest information shared by the European Union so far. Another key aspect of that regulation is the purpose limitation. So that means in general that it needs to be clearly stated and easy to find and not hidden on a page 20 or 30 of any terms and conditions or terms of usage for what purpose your data will be processed. So you know that if you log on or register yourself for an online service, in most cases, you will find their terms of usage being like 20 pages long and having all kind of information in there. According to the GDPR, that would not be sufficient because you as a user do not clearly understand without investing hours and hours in studying these terms and conditions for what purpose this service wants your data and for what purpose your data is finally being used. If a processor, so that organization you registered with, wants to use your data for an additional purpose that was not stated in their terms of usage when you sign up, he needs to get your agreement first of it all. So that means if you agreed that your data is processed to evaluate an app or a software, the processor shall not use your data to send you information about, let's say, financial investments or anything like that. According to the GDPR, that is not allowed and might be prosecuted. The next key aspect of the GDPR is data minimization. So if a processor only requires your email address and name to fulfill the kind of service they are providing, they should not collect additional personal data of yourself. So in the past, there have been these registration forms where you had to provide tons of information about yourself, about your age, maybe also about your job, about your financial status, and so on. Also, according to the GDPR, they want to eliminate that usage of data. So that means a service provider only should collect the data they really need to provide the kind of service they offer to you. Everything else should not be asked for and should not be provided. Let's talk about the common mistakes on data privacy. So the mistake number one is not educating other lines of business about data privacy activities. What does that mean? So data privacy, that is a huge change which affects a whole organization. It should not be left to a single organization. So some of our customers or some organizations I've been in contact with, they left that whole topic up to their IT department, for example, because they said, hey, come on, that is all IT related somehow. They need to update their contact and registration forms and so on. And they need to make sure that they do not save and store data which we should not store. So that would be a complete mistake. You need to involve every single employee of an organization to first of it all understand the meaning of personal data processing. Also, every employee, they need to learn about the consequences of violating data privacy regulations. So I'm referring back to these massive fines I've talked about on my first slide. And you also need to make sure that your employees get the proper training to understand and learn how to handle personal data the right way. You might be familiar with the topic about social engineering. So that means someone contacts someone within your organization to find out about data of one of your employees. That can be as easy as just making a phone call asking, hey, who was that lady within the finance department I've talked to the last time? And easy like that, you have a name, you have maybe an email address, you have a phone number, and you might even get further information out of that. So that means every single employee which is not trained according to data privacy might be a risk of you violating data privacy regulations. That is a very, very important topic. So we at OTRS, we have not only offered a one-time training to our employees, we're also doing regular trainings, which means every 3 months we're doing online trainings, which are varying a little bit. We're also intentionally sending kind of phishing emails internally where people are asked, hey, please provide your data here and there. And if someone provides their data, we understand easily we need to get these people or these teams retrained to improve their knowledge about personal data and how to keep their or the personal data of their coworkers secret. Mistake number 2 is not investigating in your vendors or providers. So first of it all, that means you have to evaluate all of your providers thoroughly. You need to find out what subcontractors or providers are they using. Is your data being transmitted in a so-called unsafe third country? So according to the GDPR, that is every single country outside the European Union. For us, as we are offering a follow the sun service desk, for example, that also meant a huge change, because what we had to do is simply separating access to the different data we are using of our customers and limiting access to that data according to the location and the country of our employees. So, for example, coworkers that were located, let's say, for example, in the United States, we could not simply allow them access to all the customer data we're having on our systems. So we had to separate these, for example. Another aspect was, so we're using many providers throughout Europe, also within states that are not part of the European Union. And we really had to restructure that cooperation. We had to make sure that we had the proper so-called data processing agreements in place. That is nothing else than a contract. On the websites of the European Union, you get the proper templates about these DPAs. You can use these to make sure you have contracts with your providers and third parties that save yourself from being compliant or being in violation with the GDPR. So that is also a continuous process. That means regularly we are checking on every single provider. We're checking whether there have been any mergers, any acquisitions which might have changed the situation and which might need our attention to get another or an additional DPA in place, for example. Mistake number 3, that is thinking that GDPR compliance is the goal. So GDPR needs continuous attention and effort to improve and adjust every single process you have in place. As I said, you need to make sure your employees and coworkers are trained properly. Oops, I'm sorry. There's some background noise. Okay. So as of today, there are not enough court decisions according to the interpretation of the GDPR in place. So that means for every one of us, we need to stay alerted. That means there will be some test cases. The Europe or countries within the European Union just started to really follow up with data privacy violations. So as you might have heard on the news, Google was lately fined with a 50 million euro fine for not providing the proper information about their services online. That was just one case. Another case lady was hitting a hospital in Portugal that did not properly control the access to their patient records. So that meant some of their service providers had access to patient records. They are facing now a fine of 400,000 euros. So really, none of us wants to be the test case. This is getting really serious now, and I expect that we will see even higher fines in the future. Another aspect very important about that is that you reassess all existing data processing agreements and adjust them if needed. I was talking about that on my last slide already. So please take care about that. All in all, don't panic. It's just another regulation. It's just the GDPR. But what I can say is over the last couple of months, we noticed an increase of approximately 70% in prospects asking us about data privacy regulations. So there's really still a lot of missing knowledge about the GDPR in place. So everyone is trying to save themselves in the best interest. But as I said, we will see the first cases being followed up and prosecuted. So there will come certainty over time. But still, please make sure that if you implement something, make sure that you take care about the GDPR regulations as well. All the efforts that is invested is because of these drastic penalties if violating the GDPR. As I said, maximum fine can be up to 4% of the group-wide yearly revenue or 20 million euro, whichever is higher. So that is a serious threat for every operation. Please make sure that you follow the GDPR, and just in case of any questions, reach out either to a data privacy officer, which can help you about any questions related to that, or for sure, we're also here. I'm not a lawyer, but I'm happy to answer your questions if there are any after the presentation.
Christopher, thank you so much for sharing that information with us. We're open for questions now. If you have some, would you go ahead and enter them into the chat? As people are doing that, Christopher, you did mention that we've had an uptick in questions come in to OTRS. Are there any that you can think of off the top of your head that would be useful to share with this group?
Regarding to these questions?
Yeah, have there been questions that would be helpful for everybody to know?
Yes, so in general, it's always about the DPAs, so these contracts I need to have in place. So as soon as an organization processes data of a European citizen, such an agreement needs to be in place. As I said, the European Union website shares all the templates related to that. They are available there in in almost every language, and you can easily use them. You simply have to fill in your company information and the information of your client, and you're good to go. So these are perfectly checked by the leaders of the European Union. That would be my recommendation number one. In general, if you are saving data of your customers, please make sure that you just save the information you really need to fulfill the kind of service you're providing. So, as I said, storing information about religion, about social status, and things like that are always questionable. You should really think about reducing that to the bare minimum.
Great. I don't know if you saw it, Christopher, but we've got one question here from Brandy. She wrote, most of our team is made up of remote workers, so we often hire people from outside of the United States. Listening to you worries me a little bit about that, because obviously we're gathering a lot of their data when they apply. Are there specific things that I need to worry about for our HR team?
Yeah. So first of it all, talking about the GDPR, it only applies if you're getting an application from a European citizen. If you receive an application from a European citizen, make sure that first of it all, you limit the access to that personal data to your HR team only. Furthermore, I recommend that you make sure to delete these records if not needed. So if you do not hire that applicant after a while, typically that means after a couple of months. So according to the GDPR, it's everyone has the right to request the number of information you have stored about them. And they can also ask you to delete that information, as long as it's not violating any other regulation or law that is in effect. And also about that application, that's always valid, limit the data to what is really required for evaluating your applicants.
Great, thank you, Christopher. I don't see any other questions at this moment. I hope that if you've got some, you'll feel free to put them in the chat, since we have Christopher here to answer those for us. Before we actually conclude for the day, I did want to let you know that if you'll be attending Pink 19 in Las Vegas next month, Christopher is going to be speaking in more depth on this topic there as well. So please feel free to stop by and visit with OTRS in person at that point. We'll give it just another minute for additional questions to come in. Oh. Hang on, it looks like maybe Brandy has a follow-up here, Christopher. She said, we have training sessions here in the United States and ask people to register for those, and then we follow up by email. It sounds like this is okay because we mostly have US people attending. Is that true, and is there anything we should worry about?
Well, so in general, if you only have US citizens attending and registering, for sure, you need to make sure that you are in compliance with US laws. So especially I'm thinking about the CCPA, the California Consumer Privacy Act, which will become effective in 2020. If I'm not mistaken. So actually the CCPA, that's quite similar to the GDPR, it is still, questionable about all the details and how California is going to enforce that. So the overall idea is that it will be only affecting Californian citizens, first of it all. But that is something you might also want to consider when collecting these registrations. In every case, as you said, you're following up via email. You should always allow registrants or attendees to opt out. So if you allow them to opt out of your follow-ups, that should be okay. But still, I'm not that familiar with the CCPA so far. That will be a different topic, but providing that opt-out, that would be a good recommendation, and also limiting the data to what is really needed for your training sessions.
Right. And I think a lot of email systems nowadays, if you're using a paid product, they have an opt-out feature built in, right? Is
Exactly.
that satisfied? Yes.
Yeah.
There's another question that came in that says, who's checking up on compliance and how will they know if we follow it or not?
Yeah, so first of it all, checking about the compliance. What we have done at OTRS, we hired an external data privacy officer. That is a recommendation I can give every organization and everyone on this webinar. That is simply an external consultant, which is certified for giving advice how to be compliant or what kind of processes need to be implemented to meet the requirements of the GDPR. So an interesting part is from the public sector, within the European Union, every country and also every state has their own official data privacy officers. As a European Union citizen, you can turn to them and you can say, you know what? I registered with this and that service. They did not provide me the information for what purpose they want to process my data. And these official data privacy officers, they have to dig into these cases and really find out what is the purpose about that processing, and they need to investigate every single case. At OTRS, we have gone through such a process only once. That is very time consuming. They want to see all your process documentation. They want to see how you store the data. They want to see how you limit access to that data and so on. So it's really not only time consuming, it's really somehow painful, I would say. So in general, every single European Union citizen, they can raise a complaint with these official data privacy officers, and then you'll be subject of such an investigation. So again, you should make sure to hire or search for advice from a data privacy officer, which is helping you implementing the right processes and so on. Then you're safe. With the GDPR, it's not like you buy a tool and then you are compliant somehow, right? You can only implement the right processes, and these processes can comply or be in compliance with the GDPR requirements. That was a long answer, but I hope I answered the question.
It's a great answer. Thank you for taking the time, Christopher. It sounds like with such a long process, it might be why we don't hear about more and more people being fined at this point, because that investigation does have to happen. Are there any other questions out there before we conclude our call for today? I think that might be the end of it, Christopher. Thank you so much for being with us today and taking time out of your day to share that information. Again, if you're going to be at Pink, I hope you'll stop by and meet Christopher in person. He'll be presenting on Tuesday from 11:45 to 12:45. Thank you, everybody. Have a great day.
Thanks, everyone. Bye-bye.